So we get a lot of calls at the law office of William Helixon about investigations. In fact, some Army officers joke that you can't go an entire career without being a subject of an investigation at least once in your military career. In the Army, there's a couple types of investigation. There are the law enforcement investigations where there's been a crime that's been alleged, or there's other investigations which are called command-directed investigations. In the Army, they're convened under AR 15-6, right? Army Regulation 15-6. What are the purpose of command-directed investigations?
The commander usually suspects that there may be some sort of infraction within his or her command, whether that's a violation of the UCMJ, Army regulation, or policy, and the commander just wants a fact-finding mission to determine whether or not such an infraction has occurred.
Right. And so an investigation is conducted, and the standard by which the investigator has to prove the allegations is by the preponderance of the evidence, and that is 50.1%. So more likely than not. Who can investigate under AR 15-6? Who are these investigating officers?
It has to be somebody that's superior in rank to, if there's a subject that's already identified in the investigation, the IO, the investigating officer, must be superior in rank to the person being investigated. It can be a GS-11. Usually it's a commissioned officer or warrant officer.
Okay. Now, if during the investigation the IO determines that maybe the commander or a superior commander has some culpability in there, they need to then go to their legal advisor, notify them, and then somebody else has to appoint someone higher in rank than they are.
That's correct.
Okay. And who can appoint these investigations?
Any commander, really. Any commander from company, battalion, brigade, all the way up.
Right.
Any commander is authorized to appoint an AR 15-6 investigation.
Now, there are 4 types of investigations that AR 15-6 talks about. They talk about the commander's inquiry, which was covered under RCM 305. Talks about the administrative investigation, collateral investigation, like those investigations that are spun up as a result of like a line of duty or accident investigation. Right. And then there's Board of Officers investigation. Let's focus primarily on the administrative investigation where the commander appoints an investigating officer.
That's the one we see the most.
Right. Now, what are the responsibilities of the investigating officer in those type of investigations?
The IO is supposed to conduct a thorough and impartial investigation. Usually the IO will be provided a set of appointment orders from the appointing authority which outlines the scope of the investigation and what particular areas of interest that the appointing authority has for the IO to investigate.
And it's the legal advisor to the IO's responsibility to keep that IO on the left and right limits of what those appointing orders say.
That's correct.
Okay. And if there are any questions that the investigating officer has, they go to their legal advisor.
That's correct. Sometimes an IO may come across a certain regulatory hurdle that they may not know how to essentially jump over, whether it's an interpretation of a regulation or how to apply a particular set of policies or how to approach witnesses in accordance with the regulation. That's what the legal advisor is there.
All right. Now, I've been appointed in my military career as a 15-6 officer before. I've conducted several investigations. And so I know that there's really no limitations on how I conduct that investigation, how an IO does. I can do telephone interviews and do an MFR. I can have a witness do a sworn statement or an unsworn statement. I can record a statement, or I can have them just fill out a sworn statement form. Are there any requirements other than conducting a thorough and impartial investigation on the IO in the manner in which they conduct the investigation?
No, really. The IO does have broad discretion to conduct the investigation just about any way they would want to in any kind of creative way. So long as it is in accordance with the regulation, there are certain types of administrative requirements by the regulation that the IO is bound to.
One of the rights that the respondent or subject to the investigation has is they have the right to either give a statement or not give a statement. What are some of the other rights that they have?
The respondent does have a right to seek legal counsel, and that is always advised in any situation in which somebody is under investigation. That should be the number one first thing you do, is go and seek legal counsel.
Should somebody who's subject to an investigation give a statement without first talking to a lawyer?
Absolutely not. That is a very dangerous road to go down if you're a respondent, because you could say some things in your response that you have no idea to the extent to which you're implicating yourself. There are so many regulations, policies, so many different articles under the UCMJ that require an experienced attorney to help guide you through.
Right. So why should someone call the law office of William Helixon when they're under an investigation?
Well, Will, you said it before. You've been an investigating officer yourself. So have I. I have participated in 15-6 investigations. I've been a witness in 15-6 investigations. We know ourselves just from our own soldierly experience.
Hell, John, I've been the subject of a 15-6 investigation.
Right, and so have I. So we know from our own soldierly experiences what ramifications a 15-6 investigation does pose. We know how to help navigate respondents and subjects through the very detailed nuances of what an investigation entails.
Well, part of the role of an investigating officer is to make findings and recommendations. And if those findings are adverse, if they are negative findings, there's also a reporting requirement now under the Army Adverse Information Program, AAIP. Now, the AAIP we'll talk about in a different video, but that reporting requirement applies to all officers, 01 and above. Do officers have a right to respond before something is reported?
That's correct. Because an adverse finding in investigation would then be uploaded into their official military personnel file, they are afforded the right to respond to that adverse finding.
Right, and so it would be very important if there is a 15-6 investigation to be able to help control the outcome of that investigation by cooperating with the investigating officer as to prevent any adverse findings. I think that's one of the main reasons you'd want to get the law office of William Helixon involved early.
That's correct, because there's a lot of different ways that you could respond to the adverse finding. You could respond to the adverse finding by simply looking at the entirety of the investigation and determining whether or not there were solid, logical, reasonable conclusions and findings made by the IO. If not, then that can be part of your response to the adverse finding itself.
Bottom line is, these are serious events and you should take them seriously. I do know this, that you can appeal the adverse findings of an investigation to the Board of Correction for Military Records, and they can review everything. That's a completely separate event, but that's also another reason that you'd want to hire the law office of William Helixson, is so that you can set up these second and third order effects later to protect your career.
There are numerous ways in which you can protect your career, and it's very important that you get an attorney on board early and often so that you can navigate all these different ways to set the conditions that you get the best outcome now, later, and much later in your career.
Thanks, John. We are the law office of William Helixson. We are protecting your rights. You defend the nation, we defend you.